Good morning, everyone. I don't need a microphone because I have a big mouth. So I know on the flyer there was a picture of the county executive, and you can tell that I'm not him. Right? So I just want to send apologies. He did have a conflict in his schedule, but I'm Shakita LeGrant McClain. I'm the executive director of the Department of Health and Human Services, and I just want to welcome you to our brand new Health and Human Services Marsha P. Cox building. What do you all think? So thank you all for joining us today for this important event in honor of Mental Health Awareness Month. Each May, we recognize Mental Health Awareness Month to help us better understand mental health, reduce stigma, and provide a connection to services for those struggling with mental health issues. In Milwaukee County, we have moved from an institutional model of behavioral health care to bringing services to community-based locations, meeting people where they are. And we are serving more people on an annual basis with the locations that we have. So in 2021, we served just under 15,000 residents. And in 2024, more than 16,200 people access behavioral health services. Our behavioral health services include our community access to recovery services, also known as CARS, our comprehensive community services. We have access clinics, the Milwaukee County Mental Health Clinic, our wraparound Milwaukee Children's Community Mental Health Services, as well as a number of other services and locations and a number of partners that we work with each and every day. We also have our Milwaukee Mobile Crisis Team, which is available 24/7. And our mobile crisis clinicians are dispatched throughout our community to provide in-person assessment, stabilization, connection to services, and appropriate follow-up. If you know of a child or an adult having a mental health or substance use crisis, I encourage you to call our Milwaukee Mobile Crisis Team. You will hear more about that today and how it works in just a moment. I also want to recognize our Behavioral Health Services Administrator, Mike Lappin, for bringing us here together today, along with our distinguished guests on the panel. We have some amazing people. Y'all give it up for our panel here today. I would like to thank you all for being here and your commitment to educating our community on the mental health system and the mental health laws in Wisconsin. So with that, I would like to turn it over to our moderator and our amazing administrator of behavioral health services, Mike Lappin.
Thank you, Director LeGrant. I too probably don't need a microphone, but I'll use it, I think, for the recording. Can you hear me?
No.
Sorry. All right. See, I don't really need a microphone, but I'll use it. Thank you so much, Director LeGrant. It's so fun to see you all here. This is our first official event for the public here at the new building, which we really just started moving into within the last couple of weeks. So it's very excited to have you here. It's an accessible building, which is a huge upgrade over our old space, which is really hard to get to. So thank you all for coming. It's Mental Health Awareness Month. The most frequently asked questions that are presented at our listening sessions, that come to me directly, that I hear about in the community, typically revolve around the involuntary treatment system in Wisconsin. I know many of you have probably had a challenging experience in that system. I have as well. I have a family member who's been involved in that system a couple of times. I know it's a challenging system. The idea here, though, is that we're not going to be able to really talk about individual cases with the panel. I will be available for any of you who want to email me a particular situation or challenge, whether it's with me or with the panel. Your questions will be answered for sure. We have a list of submitted questions. If we can't work in the answers, I will put out a formal response that everybody will get. I believe when you're registered, you can provide your email addresses. We'll also put it out on our page. There's some really great questions. They're just way too complicated for the panel to answer today. The hope here is that we will walk through this system as it exists today, and each sort of part of the system. So we'll sort of walk through hypothetical cases we'll start with mobile crisis. We'll work with the Mental Health Emergency Center. We have our legal representatives. We have our chief medical officer. We'll sort of talk about those different places in the process. And we will talk for a bit about when someone is on a commitment, sort of what are the curves on that, what we can do, how people get returned to more restrictive status, really what are the bounds and the expectations that you could have for someone who's involved in the involuntary system. So each participant will kind of introduce themselves and talk about their roles or as they walk through the system, and then we should hopefully have some time at the end for a couple of questions. So I guess we'll start with Lauren Hubbard, who is our leader of our crisis service, but I'll let you introduce her. So Lauren, thank you.
Thanks, Mike. Good morning, everyone. Can you hear me? Okay. Okay. So I am the Director of Community Crisis Services for Milwaukee County BHS. The primary focus of my role is working with the Milwaukee Mobile Crisis Team, our CART teams, and services provided over the Milwaukee County Crisis Line, among other things. But what we're here to talk about today is our ability to support Milwaukee County residents, their personal and professional supports over the crisis line, and also to come out in person to offer in-person assessments, support, linkage to services, and to help get people the help that they're looking for. Typically, the first contact with Milwaukee Mobile Crisis Services is through the crisis line. And I'm sure that number will be posted somewhere for you, but it is 414-257-7222. That service is available 24/7 to have access to a mental health clinician, to help provide, again, with over-the-phone assessment, talking through education on mental health and substance use needs. We work to de-escalate over the phone if possible, and also to provide resources and linkage to other services. Through those phone calls, we also work to determine when it's appropriate to come out and respond in person. Right now, our in-person services are available 7 days a week from 7:30 a.m. till midnight. Next month, we should be launching third shift services as well, where we are happy to be able to provide support to people in person over third shift hours as well. So more to come on that. But what to expect in an in-person response? That is still time spent with a team, either of licensed mental health professionals, registered nurses, or master's or bachelor's level clinicians who are working up towards their 300 hours in training as well. We'll provide those supportive services, assessment, including a mental status examination, risk assessment, substance use screen, among other things. We work with that person, their loved ones, or their professional supports on site, again, to de-escalate and help mitigate crises, and also to assess for safety. One of the main things that we're looking for in working with people when we show up on site or supporting them over the phone is, are you safe? And how can we link you to the appropriate level of care or community-based services in order to help keep you safe? At times, and hopefully more often than not, those options are voluntary services where clients can either go to an emergency service or inpatient care for intake assessment, or we're helping to link them voluntarily to community-based services, which may be case management. It may be helping them get to an access clinic. It may be working with them on their insurance provider and seeing what options are available for them in the community as well. And that all is a part of, again, what that risk level might be, the safety of that person and the situation that they're in right now, and then also the choices of that person to be able to have self-determination and pick what options are appropriate for them. At times, the outcomes of those assessments may be requesting support from law enforcement to assess for the need for a Chapter 5115 or an emergency detention. The clinicians on the Milwaukee Mobile Crisis Team do not have the authority to detain community members or to remove them from places. We also don't have the authority to admit or place, but we're working with our system partners who do have that authority to make decisions along with our assessments. So in the case that someone may have a safety need, inability to care for themselves, or harm to themselves or others, then we may work with law enforcement to detain someone, and from there they would either be going to an emergency room or to the mental health emergency center, which Dr. Owen will talk about shortly. Following those assessments and our in-person responses, typically clients remain in the community, but either way we'll work to also provide follow-up care. So that is, again, more phone calls or in-person visits to that person, their loved ones, the professional supports that are helping to take care of those next steps with them. And those follow-up contacts are checking in to see how things are going. The linkage to services, were they appropriate? Did you come across any barriers? Is there any problem solving we can do? Is the crisis mitigated? Is it resolving? Or should we come back out to assess some more and provide further support? Last year, the Milwaukee Mobile Crisis Team had over 2,000 crisis line contacts and over 10,000 in-person mobile assessments. Just some numbers for that. The percentages of those served last year, 20% of those were youth, 15% older adults, and the remaining 65 adults aged 18 to 59. And then the other side of that service, a sister mobile crisis team, are our CART teams. We operate CART teams in partnership with 4 different law enforcement agencies at this time: the City of Milwaukee, West Dallas, Wauwatosa, and also the Milwaukee County Sheriff Office. CART partnerships include dedicated law enforcement officers from those specific agencies and trained mental health clinicians who have the same role as the mobile crisis team that I just described. So in those situations, CART is typically accessed by calling law enforcement, either through 911 or the local non-emergency for those different agencies, either in the City of Milwaukee, West Dallas, Tosa, or the Sheriff, and working with those officers to respond on scene. Our CART officers are all CIT trained or crisis intervention trained. They have applied for these roles, so they have passion and experience working with individuals with mental health and substance use needs. And we pair them with our crisis clinicians. They respond to those requests for services, either as dispatch asks them to go out, or regular patrol officers who respond in the community and feel like once they've showed up, there's a mental health or substance use need, then CART can be requested. In these situations, CART is called out as a consult to help, again, make those decisions once on scene about safety and what the best next steps for that person and their loved ones might be. In situations where CART responds, for last year's stats, less than 6% of those calls that CART responded to were people placed on an emergency detention. CART's goal is to work with people for voluntary options to help uphold their rights and to make decisions again for voluntary treatment when possible, and when folks need to be detained, that is truly a valid emergency detention that is going to see its way through this process. That my panel members will also explain a little bit more about too. What else can I say about CART? And I think the last thing for CART, our different jurisdictions also have different service hours, so those do vary. For the City of Milwaukee, CART is available 7 days a week, typically from 8 a.m. to midnight. We have 5 teams, up to 5 teams that may be in service per day. West Dallas and Wauwatosa operate Monday through Friday from 11 a.m. to 7 p.m. And then our partnership with the Sheriff Office is currently 5 days a week, Monday through Friday from 11 a to 11 p.
Thanks, Lauren. I guess the one thing I would just follow up with you on is frequently CART and Milwaukee Mobile Crisis are confused. So someone will come and talk about an experience they had. They'll either say, well, CART came, or mobile came and didn't take the person away, and why did they do that? And so can you talk just a bit about the fact that Wisconsin is one of 2 states that law enforcement is the only party that can take someone into custody, and how that impacts the situation when a CART team responds? Really, it's the officer that leads the call. And can you just talk a little bit about how that works and where our authority sort of ends?
Yeah, absolutely. So in the service model that Milwaukee County has with our various CART teams, our clinicians are embedded into the law enforcement operations that will be happening anyways. So our community at times calls 911, there's a safety concern, and law enforcement shows up. In these situations where CART is dispatched, our clinicians are riding along with officers, again, to help be the crisis clinician on scene, offer their perspective, provide that mental health resource, education, and talk over the different linkages to services that might be appropriate. However, our clinicians are civilians, and so they are not in control of that scene. We work with our CART partners, the officers that are actually a part of those teams, who have knowledge. Our CART officers are trained with our crisis clinicians, with our Milwaukee Mobile Crisis team. They get the lay of the land about what the human service perspective might be. But there are also times where, again, we're consulting on scene for a situation that has already been secured and is being controlled by other agencies in that moment. So we do really work to collaborate. We work to provide that consultation, provide advice, recommendations, but at the end of the day, that authority to make decisions on detentions are up to law enforcement. There are also times where people may call the crisis line, and again, depending on the situation, if safety is a concern, Milwaukee Mobile Crisis may request support from law enforcement to make that determination, again, for are you safe today, and how can we ensure that you'll be safe throughout the night into tomorrow.
Thank you. there'll be an opportunity for folks to ask more specific questions. We're gonna kind of go through the process here. We'll collect them. So just for the sake of the conversation, whether it was CART or some other law enforcement officer, an individual gets taken into custody under 5115. The idea is that they are a person with a mental illness and that they are imminently dangerous to self or others. Wisconsin has a county-based system, so each county has responsibility under state law. Milwaukee has a very specific provision that requires a county contracted or credentialed physician to provide what is called a treatment director's supplement. That today occurs at the Mental Health Emergency Center, which is led by Dr. Owen and her team. And that service really replaced the longstanding service that many of you who've been around for a while will remember as the Psychiatric Crisis Service, or PCS, that was out at our place on Wellington Plank. So in that context, person is taken into custody now after, again, could have been CART, it could have been NPD. They bring them to the Mental Health Emergency Center, which is about 50 yards that way, and then Dr. Owen's team has a role and works with us very closely. So, Dr. Owen?
Thanks, Mike. Good morning, everyone. I'm Julie Owen. I'm a psychiatrist and also the Chief Medical Officer of the Mental Health Emergency Center, or MHEC as we call it. We opened our doors in September of 2022. In calendar year 2023, we had over 7,600 patient encounters. In calendar year 2024, we had over 7,800 patient encounters. We skew about the same as Crisis Mobile. About 80% of our patients are adults, about 20% are minors. And when I say 7,600, 7,800, that's not all unique patients. We have some familiar faces that we see. We've served roughly 4,500 unique patients in last calendar year. When a patient arrives to MHEC, roughly, we skew a little bit more toward our voluntary patient population, but roughly it's 50-50. Half of the patients that come to us are there not because they want to be there, but they're brought involuntarily under Chapter 51. The remaining half come on their own, and they can arrive anyway. Most of our patients do come with law enforcement, so about 76% of our patients arrive with law enforcement, but about a quarter of those are coming because they want to be there. Once they arrive, we are a licensed emergency department, so our doors are open 24 hours a day, 7 days a week. Being a licensed emergency department, we're bound by EMTALA, which is a federal law, which means that we see every patient that comes to our door. Doesn't matter the age, doesn't matter anything else about them. There's no requirement that we have that they stop in a medical emergency department first. We are staffed by physicians, so the first thing that we do is do a medical screening examination where we assess patients for any sort of medical emergency that might be happening. And if we suspect that, we will work with our community partners, our medical emergency departments, and transfer those patients out. With the understanding with our medical EDs that we will take them right back after they're evaluated, deemed to be medically stable. When a patient enters our doors, they're greeted by a triage team that consists of a nurse, a public safety officer, a registration team member, and also a behavioral health technician. They are all trained in CPI, or the Crisis Prevention Institute, which really focuses on verbal de-escalation, therapeutic interventions, etc. Once they've been triaged and sort of their acuity assessed, we make sure they're not having a medical emergency. One of our board-certified psychiatrists will see the patient. All of our psychiatrists are treatment director designees, which means that they have gone through special training that's provided by Milwaukee County to ensure that our docs are incredible experts at the sometimes difficult, complex Wisconsin state statute around Chapter 51 and how we treat those patients. They get their assessment by the psychiatrist usually within about 30 minutes of crossing our threshold. So it's a very, the sort of progression to care is very quick. The fact that we are staffed by psychiatrists doesn't just mean that we are assessing somebody and trying to figure out where they go from here, but we can also initiate treatment. So if somebody is presenting with acute symptoms, we can offer treatment right away. We have a crisis stabilization model, which means we have two open milieus or environments for our patients. One is for adults, one is for our minor patients, so there is no interaction or mixing between the two populations. And we keep them until we feel that they're stable. And if we feel like they're not going to stabilize fairly quickly, we work to get them to their next step, which is always an inpatient psychiatric hospital. Our stats have remained fairly stable. We send about a quarter of our patients to an inpatient facility. Anything else that you want me to cover right now?
Well, one quick follow-up. You mentioned that 76% of the patients come to the police, but only about half are involuntary. Can you just talk a little bit about, I think that's something that NPD, the Milwaukee Police Department, is part of their policy that they will convey someone who requests a transport to MHEC as a voluntary. Can you talk a little bit about the challenges that present, though, in that sometimes people arrive and the police leave and they're assessed, they don't meet criteria, but then you can't hold them. Can you just talk a little bit about the nuance there?
Sure. As Mike mentioned before, we're one of 2 states where only law enforcement can place a Chapter 51 or emergently detain somebody. That includes if they are in a facility like ours, our psychiatrists have to call police just like anybody in the community would. So if we see a patient who starts out as voluntary, wanting to be there, and then they request to leave, we have to call police if we're very concerned about them, and ultimately the choice as to whether or not the individual would be chaptered would be on police. So even if we have safety concerns, the ultimate decision doesn't rest on us. If we don't have safety concerns, even if we think this person would really benefit from treatment, legally we have to let them go.
Okay, thank you. So we have Al Poland, Attorney Poland represents our core counsel. He can introduce himself, but really once the case, so we move forward, the emergency detention happens, the physician at the Mental Health Emergency Center signs this treatment director supplement form, and there's some legal stuff that happens behind the scenes, but essentially then Corporation Counsel represents the county in that case, the county department, I believe, and maybe I'm saying that not exactly correct. So that's where Al comes in. He will explain it from there.
Hello, all. No? Hello, all. Thank you. Thank you, Katie. I'm being like a lawyer, so I'm taking notes as I'm listening to the presentation. So I do want to just add a couple things from the presentations. When I started practicing law back in the early 90s, and I did this as a defense attorney, and many administrations before Mike and Dr. Schneider, we had a pilot program in the statutes. It was based upon a Jefferson County model that allowed clinicians to go to the scene and they could make the detention decision. In Milwaukee, we called it the yellows. When police do it, we call it the blues because it's a blue form. And when the clinicians did it, it was a yellow form. It didn't survive the pilot period, but there was at least a short period of time where a team of clinicians can go out and they could make a decision to take someone in protective custody and bring them to a reception hospital. If anyone's ever wondering, this 24-hour rule that Dr. Owen talked about and Mike talked about is Milwaukee County only. So when someone is taken into protective custody and everything is time-based, they are brought to a reception hospital. That custody that law enforcement has is transferred to a treatment director designee that would be at MHEC. And then they would have to make a detention decision within 24 hours of when they're taken into protective custody in the community. In any other county in the state of Wisconsin, when they're taken into custody, they are delivered to a reception hospital, and when they're delivered, they're detained. So I always wondered, why Milwaukee County? Why us? Why this misfortune or present, whatever it was? And I always thought it was just because we're huge. And we have a lot of volume, and maybe because we have this volume, there's this obligation, instead of waiting potentially 72 hours before you get to bed hearing, to triage these cases earlier, have a treatment provider eyes on within that 24 hours to make a detention decision. Well, at one point, I went to Marquette Law School, and I went through the microfiche, and I found the old working group. It went back to 1977 or 76. And there was a working group initiated by Milwaukee County, working with our legislature, wanting the law to change to allow doctors in the state of Wisconsin to have the authority like law enforcement does. to initiate a petition. And the working group decided, thank you, but no thank you. We're going to keep it as it is, but we're going to give you a parting gift, Milwaukee County. You and only you, when someone is detained, we'll have a doctor we'll allow Milwaukee County to have a doctor make that decision. There we go, sorry. Which wasn't what, I don't like that. Which wasn't what the working group from Milwaukee wanted in the first place, but that became the law, and it's never changed. So that's why we have this 24-hour rule that Milwaukee County never asked for, but we got it. So I'll go into my spiel. So
Yeah, real quick, a clarifying question then. So in that context, when folks will come and they'll make a comment that, hey, in another county, they detained my loved one and Milwaukee operates differently. What I believe the difference is in that county, that individual may have been admitted, and because the treatment director supplement is a 24-hour rule, 24 hours max, there's no extensions.
Right.
Because the probable cause rule can go 72 hours, some people end up being hospitalized for 5 days without going to a hearing. I think that's the difference that gets misunderstood. And I can use
right. We have our law changes a little sometimes, and one of the changes was what happens when someone's not medically clear, and what happens if they have to be at a hospital to get medical treatment. So there was a change where Milwaukee County could toll the time to make that detention decision, but we couldn't toll the time to have that first hearing within 72 hours. So it's a little helpful, but for the people that are in an ICU at Freighter, maybe our team that goes out has 48 hours or maybe a little more time to make that detention decision. So I've been doing this I've been a lawyer for about 32 years. I've been doing this for the county for 16 years, I think, and the probate work in our office and generally Chapter 51 and 54 and 55. I have a work partner. I've had many work partners through 15 or 16 years. One of my work partners is sitting in the back, who's my new boss, Jennifer Rhodes. We have, when someone is taken into protective custody and they're brought to the Mental Health Emergency Center and a detention decision is made and they're served with paperwork, we are going to have what's called a probable cause hearing if the case doesn't resolve or the person's status doesn't change from involuntary to voluntary care. We're going to have a hearing within 72 hours, not including weekends, not including holidays. And unless the defense attorney adjourns that, we can't adjourn it. So we're going to have that hearing. Our hearings are Monday through Thursday, and we only hold them in the morning, and we do it by Zoom. And if we get probable cause, and that involuntary hold now is continued, so they're going to be on a very nice hospital unit in one of our many contracting hospitals that we have throughout the city, and even some outside the county. They're not going to be able to check themselves out. They're not going to be able to walk out the door. So that probable cause hearing is about whether or not the court is going to kind of authorize an extension of that involuntary hold if I can prove what I have to prove, that they have a treatable mental illness, they are a proper subject for treatment, and they're dangerous. And a lot of times what the families struggle with, and we deal with it, is that dangerousness portion. People can be mentally ill and not agree, and there's nothing government can do, and they could be symptomatic and not treat, and there's nothing government can do until they cross that line and become dangerous. Then they can be taken off the street. Then they can be held involuntarily, and then they can be treated whether they like it or not. And our dangerousness is a lot of times what you would think dangerousness would be. They're threatening to hurt themselves, they're trying to hurt themselves, they're threatening to strike out at others, they're striking out at others, they're omitting to engage in behaviors that are going to keep them safe, to where if we don't treat them, they're going to do something potentially, not intentionally, but they're going to harm themselves. And those are kind of our examples. And we have a fifth standard too. I'm not going to go down that road, but there's all kinds. We have statutory criteria for dangerousness. It's pretty straightforward, and that's a lot. Ms. Holtz and I a lot of times, and her staff. That's what these cases really turn on. Do they meet criteria for dangerousness? And when they're fighting a case, if they don't, people are discharged. A lot of times discharged against medical advice, and that's just the way it is. And that's our system. If we get probable cause, we'll have a final hearing. That final hearing is within 14 days of when someone is taken into custody on the street, unless the defense adjourns it. Again, it could be adjourned up to 7 days. That final hearing, we'll normally have them on Fridays. They're by Zoom, unless the patient requests an in-person hearing, and then we'll do it in person. So it's kind of the same burden of proof that I have to show with the illness and treatability and danger. And for those people that we're pursuing a commitment for, if I'm successful, I'm going to have a court make findings that we have a commitment order to the care and custody of Milwaukee County. The order can be up to 6 months max initially, and they're subject to extensions, and those are people who continue to be dangerous, people who continue to lack insight into their illness, the people who are not receptive to getting treatment voluntarily. We could potentially extend their civil commitment order, and that order can be extended maximum up to a year. Am I way over here?
I think you're on. You just, when you're done, you can just stop.
So what Ms. Holtz and I will do, and I don't want to step on her feet here, we'll get that petition that comes from the Mental Health Emergency Center from BHS staff. Ms. Holtz and I will get it at the same time. I'm looking at it to see if it's legally sufficient. And I'm stuck with however that petition is. So it's the only area of law where non-legal professionals are authoring a petition that's our petition. So if they do it right, we're okay. If they do it wrong, we're in trouble. So whatever it states on that petition, whatever witnesses are listed by law enforcement, if this is one done by law enforcement, that's served on the patient when they come into the hospital, that's filed with the court and served with the parties, that's what I have to work with. I can't add people. I can't add information. So hopefully there's enough there. If there's not, a case could be dismissed, potentially. But I work with what's on the petition. I'll talk to the treatment team that'll have this individual. We'll see where the treatment is going. We need to potentially adjourn this case, get a little more time to get a better idea of how they're doing before a hearing. Can this case be resolved with what we call a settlement agreement, where we suspend the proceedings and enter into a treatment order, and hopefully they're successful on it. And if they're not, they could be brought back in, and we can reinstitute the court proceedings. Or do we proceed and get a probable cause order where we continue this hold? If a treatment team is advising us that they want a certain posture, we want to go forward with probable cause, we'll be in contact with the defense. We'll know what's going on in real time with the treatment team, and Ms. Holtz and I and her staff. We have constant contact with each other, texting and calling each other throughout the day, prepping the cases. And I'll reach out to witnesses, and usually it's the day before, asking if they can participate. It's usually family members. And we get them on a Zoom call, and we might have a couple of them scheduled in the morning. I'll figure out what's going to go first and what's going to go second based on when a defense attorney is available, when a witness is available, when we can get the patient on the Zoom. But we usually don't go into the afternoon, and we'll have that hearing. And then we'll have an order from the court either continuing the hold or discontinuing the hold, or some sort of a treatment order in place, and then the case is kind of on pause. But what everyone's got to keep in mind in this process too, I've been around a long time. When I started doing these cases, we were kind of starting to move away from institutional care. And now where I am right now, it seems like a blink of an eye. I'm 57 and it's 32 years later, but we have moved way away from institutional care. And our legislature has definitely moved away from institutional care. We've included legislative policies where community treatment is the default setting. Involuntary holds are the exception to the rule. So we're in a world right now where we do our best to treat people, limit their stay inpatient, and maximize their treatment while they're in the community. But if and when people are under orders and can't be maintained in the community, stop cooperating with treatment, there's a process. And I don't know if Doctor, are you going to talk about that process?
Yep.
Dr. Schneider will talk about the process of when they're under treatment orders, how do we bring them back into the hospital, sometimes kicking and screaming, to get them better.
I think we're going to give our
It's me.
Oh, sorry, Katie.
partner from the Office of the Public Defender to introduce the kind of, debating with Al. So I'll let you guys take it here.
So I'm Katie Holtz. I am an attorney manager at the Public Defender's Office, and when people think about public defenders, they think about criminal involvement and things like that. But we really, in our office, think of ourselves as civil rights attorneys, really arguing and fighting for the civil rights of our clients and the patients against all these lovely folks up here, holding them to their burdens, holding them to account. Because Wisconsin has a very libertarian, not in the political party sense, but in the stepping back and really trying to limit government involvement in people's lives. Everybody has a right. You have a right to have a mental illness, and you have a right to live in the community unbothered and unharassed by government, unless you're doing something that crosses that threshold, as others have said, into dangerousness. And our statutes and our Court of Appeals, who kind of checks all of us on a regular basis, reminds us of that it's a pretty high threshold. And my job and my team's job, I manage a group of attorneys, our job is to really push back and really make sure that people's rights are being protected, and that they're understanding the process. And really, if the government, if Al's crew and BHS is really going to make a push to hold somebody and have involuntary involvement in mental health services in their life, our job is to push against that if that's something the person doesn't want, and push back against it. And you heard a lot of timelines: 24 hours, 48 hours, 72 hours. And when we get that petition that Al was talking about, we look at it to make sure those timelines aren't blown. And if it's blown, we make motions to dismiss, and they're getting dismissed. And that's part of that's not just what we do, right? But that's part of what we do, is really push back against that. The Public Defender, as people may or may not know, is a statewide agency, but in Milwaukee County, we kind of have three kind of divisions or areas that are focused on. We have folks that work on our criminal side of things, representing adults that are accused of crimes. We have folks that work at children's court that are working with kids accused of delinquencies and interacting with child protective services. And then we have our crew that works on people on Chapter 51s or who are having guardianships and protective placements put into place. I've been doing this not as long as Al has, but for enough time that I've kind of seen things grow and shift and change. And the other unique perspective I think that I have is, my family is also a consumer of county mental health services. My son is involved in CCS, so I can kind of see it from family perspective and public defender perspective, which sometimes creates a mishmash in my head of what I want and what I don't want, because as a mom, you think of something very differently than you do as a lawyer. But when somebody is emergently detained, or that blue is filed or the TDS is filed, it starts a court process, and we have a very short amount of time as lawyers representing folks to go and meet with them and try to sort through what's going on and prepare for contested hearings essentially a day after we get them. There's not a lot of other situations where you're doing a hearing as a lawyer within a day. And so what we do is we look over the paperwork to make sure it's met the expectations of the law, and then we fan out in the community. We're going to Rogers and Brown Deer. We're going to Rogers and West Dallas. We're going to Granite Hills to see people. We might be coming to MHEC to see people if they haven't been transferred yet. Aurora Psych is the other big one that we go to. Sometimes we go to St. Francis or some of the other inpatient mental health units. And we're meeting with people and talking with them. A couple things that people struggle with understanding attorneys' roles and things is, First of all, no matter the age of the client, we've had kids as young as 6 that are emergently detained. We might look at a case differently than that, but their rights are the same as if they were 18, as if they were 80. And so our role changes in, again, how we're going to interact with somebody, but it doesn't change in terms of their legal rights and things like that. And I hold attorney-client privilege with my clients. So something that often frustrates people is they'll call my office and want to talk to me or my staff about what's going on, and without permission from my client, again, even if they're in a mental health crisis, I'm not talking to anybody. I'm not even calling people back sometimes because I can't even acknowledge that a person is a client unless I have their permission to do so. And that's a really, again, putting on my mom hat, that's a really hard position to be in because I love somebody and I want to know that information. But that's our role, and we have to be a safe space for folks to talk through things and talk about stuff. So that's why we have that. The other thing that we have is we presume everybody is competent to make decisions about their lives and their cases. And so somebody could be in a state of catatonia or in a pretty strong psychotic break, right? And they could be talking about things that do not make sense in the reality that I live in, right? But it's their reality in the moment. And I don't judge that. I don't think like, you're talking a little bit not like you're in reality, so I'm going to discount what you say. I am an express wish attorney. So my job is to talk with people about what they want and then do my best to effectuate that within the systems that we have. I am not a guardian ad litem whose job it is to represent the best interest of people. I represent what they want. So as we're talking about things and sort of talking with treatment teams and the county about how to go forward on something, we're also talking with our clients and spelling out options to them. And they might, logically, I might think it's the best for somebody to have a settlement agreement or, a hold open agreement, they're called some places. And they're like, nope, I want to go to court and I want to fight this. And I might think that's the worst idea in the world, and it doesn't matter. I might have conversations with them in private about how I think that's a bad idea, but I'm doing what they want me to do within the bounds of the law, right? Like I still have to follow the procedures and things like that. But my job is to do what they want, not what's best for them, not what family members want, not what the doctors want, what the person sitting in front of me who I'm talking to and representing wants. So that's a role that my staff and I take very seriously. We view ourselves as empowering people who often are in situations where they don't have a lot of power. I'm their only source of power, right? And their voice is their only source of power, and we take that very seriously. And we, again, are going to have real conversations with them in private as we're counseling, because, they call lawyers counselors at law, and that's a big part of our job is to talk with people. But when it comes to going into court, I could see somebody is very, very sick and probably objectively needs some treatment. But if they've blown that 24-hour deadline, I'm moving to dismiss that case. If the person then wants to engage in voluntary treatment, they absolutely can. But I and the folks we work with and the law believe that if these very strict procedures aren't followed, somebody should have a choice of whether they or not they participate in things. So the other thing is once somebody is committed, so once we go through the whole process and they have that final commitment hearing, and they're on a commitment for 6 months, and then it can be extended for a year ad nauseum if the county is seeking to do so and the court approves it. Our role changes a little bit. I don't view it as our role to enforce what they're under. I might check in with people. I'll answer phone calls for folks, but it's not my job to make sure they're complying. What it is my job to do is if they're not complying and come back into the hospital, it's my job to, again, advise them of their rights and fight for what they want. And if their order is going to be extended or if it's sought to be extended, my role is to talk with them about their options and go with what they want. So if there's a lot of people when their orders are sought to be extended so they can remain on a commitment who want that support and services and are agreeing to extensions. But if they don't, that's my job to go into court and argue to the judge or a jury that they should not be extended and to hold the county again to its burden and to make sure they've been providing the services that folks deserve and that folks are under this commitment to kind of be treated, get better, and get off of the commitment. There used to be some folks that were on commitments for decades. And the county's really moved away from that because at some point it's not treatable anymore and you have to look at it through a different lens. And so that's kind of the role of public defenders in this whole system, is we're really the ones that are pushing back against stuff. And we sometimes might be your best friend and sometimes might be your worst enemy, but that's a role that we really cherish and we really think is important in the whole system as a whole.
Thank you. There's probably a couple of back and forths with you guys. Valerie, your first rebuttal?
My first rebuttal.
Oh, man.
No, just I take notes. So what Katie was talking about in our 51 process, I'm an attorney, and at the point there's a petition, I'm advocating for the public. I have a client that will be the county department, a treatment team that I'm getting input from, but I'm an independent decision maker. And Ms. Holtz is an attorney advocating and not acting in the best interests, because sometimes they're not the same, for their client. If this were a guardianship and protective placement proceeding, I'm not going to get into the differences there. But as far as the parties in those proceedings, you're going to have an advocate and a defense attorney from the public defender's office. You're going to have an attorney, like potentially could be me, or a private petitioner. But you're also going to have an attorney appointed that's a guardian ad litem, and that attorney is going to be acting in the best interest of subject patient. That's different from our proceedings. We don't have a guardian ad litem in our proceedings. Also, our proceedings are closed, so I should be thinking with my audience here, what are the things that they're thinking about that they're upset with in this process? And a lot of times what I get is they want to know what's going on. They want to be in the proceedings. And unless in our 51 world, if you're an adult and you don't want your mother or father to be part of it, and they're not witnesses to anything that I'm calling, they don't get to participate, they don't get to know anything. And they're going to call me and say, what happened? Or where is he? Or what's the treatment plan? A lot of times I don't know what a treatment plan is. And unless I have a signed release, I can't talk about it. And it gets, a lot of times, family members very angry with me. But that's just, and Dr. Schneider will talk about HIPAA protections in our world. These aren't public proceedings, they're private proceedings. I also can step into your shoes and understand, well, I don't care about the law. That's my son. He lives with me, and I want to know what's going on, and he's not telling me. And that's the problem we deal with every day, where we can't. Lawyers can get charged with a crime for violating HIPAA, but more importantly, lawyers can get dinged with an Office of Lawyer Regulation if a complaint is made. So we don't want to violate HIPAA. Most of our cases are statements of emergency detention by law enforcement. That's not all of our cases. Sometimes someone's on an adult on a locked inpatient behavioral health unit requests discharge, and they're voluntary patients, and the doctor doesn't think it's appropriate based on whatever criteria. They have the lawful authority to initiate a statement of emergency detention. That's the one exception where a doctor, actually there's another exception where a doctor can do that. But it's for a lot of our patients who are engaging in dangerous behaviors on the unit, or not treating or requesting discharge before they're treated. A treatment director's got to let them go, or they have the ability to perhaps file their own petition that gets served on them. They're going to stay where they are. They're not going to go through the Mental Health Emergency Center. We also have three-party petitions, so for people who are here or people who are on, a lot of times people will come through our office, and we have three interested parties with allegations of a pattern of dangerous behaviors going back maybe 60-ish days. We can author a petition that would have to be approved by the court, that would then go to the sheriff for pickup in the community, and they would come back in. That's another frustration level with family members who are very, very involved in the three-party petition process. Feel like kind of this member of the team to get this petition off the ground. And then once they're served and brought in the hospital, they're cut off. They don't get the information anymore. And they are very angry about that. And again, that's a HIPAA problem that we always have to deal with. If you come in on a statement of emergency detention and you're a juvenile, parents get served with the paperwork. They get notice that a petition is done. They have a right to be present at that hearing if they choose to. They have a right to have an attorney. They have a right to provide input as long as it's a juvenile. Not a juvenile, you're dependent upon your loved one to get that information. In just our petitions, we have one's done by doctors when they're voluntary, 3-party petitions. We have people who get arrested in the community and they're not competent, and their criminal case gets converted into a civil commitment proceeding. We have people who are charged with a crime, can assert an affirmative defense, and they're found not guilty due to mental disease or defect, and prior to the expiration of that criminal commitment, a treatment team could initiate a petition that will come back to Milwaukee County, and that's another petition we could potentially get, and that's a petition initiated by a doctor, usually at one of the institutes. But most of the cases we get, I always put a number by it. I don't know if it's true. Dr. Schneider could tell me I'm wrong. 85% of the petitions we get are usually done by law enforcement. And those are single act incidents coming out to the residents, and it's their decision. And whether they're coming to your house in the community, whether they're going to a hospital and the doctor says, hey, we want you to detain this person, here's the information. It's the law enforcement officer's decision. And if they don't think the person meets criteria, no family member has a trump over that decision. It's the decision's made, and they're not going to take them into protective custody.
One quick follow-up question, and then we'll move on to Dr. Schneider to talk about sort of the procedures once people have a commitment in place. You had mentioned something that I know is a challenge. Can you talk a little bit about what the fact that what you have to work with is limited to the petition? So, for instance, that blue form, the famous 5115 statement of urgent extension, that's the only source, really, for that probable cause hearing for dangerousness, correct? Can you talk a little bit about that?
So what happens when law enforcement comes out to your place? They interview you, and you tell them, my son Joe, before you came here, picked up a knife and threatened to kill his sister. And then the law enforcement officer comes out, writes the petition, and lists mom as a witness. And now they come and no one else. And it comes through, and now I reach out to mom, and I ask her the questions about what happened, and I try to get a little more specificity. She tells me, well, I didn't see it, but my daughter called me. I was working, and she told me that this is what happened. We don't have daughter listed as a witness by law enforcement. I can't add her as a witness. And I can't have mom testify to what daughter told her because it's hearsay. So that's the problem we get ourselves into. And we do CIT training, and we talk to the sheriff, and that's one of the things we stress. We'll always say, make sure, list everyone that has personal knowledge and lay it out in a way that your 8-year-old kid could read it and understand what was going on. Because if your 8-year-old kid can understand it, I'm going to understand it, and then our court commissioner is going to understand it. But once in a while, we'll get the petitions, and we learn the day before that we're not going to be able to prove it.
Thanks, Al. Katie, do you have something to add to that? Okay. That is a source of frustration. I get it. I've been involved personally in a situation where that petition didn't work for a family member. But I know that you don't control that. And the facts are the facts. The witnesses are witnesses. I think many cases do get thrown out, and it creates this sense that the system doesn't care, that the system, we're cold. But it really comes down to basic legal premises, and I think that's something that we wanted to convey today. But moving on, we'll have some more time for the panel.
But also the hospitals do, when they'll know that the hospital will know in advance that we have this problem. And they usually do a really good job. And we don't sugarcoat anything. They'll tell them what's going on, the problem, and give them an opportunity, encourage them to sign in voluntarily. And a lot of times they just choose to sign in voluntarily. They've started taking meds, they're getting a benefit, their insight is starting to come back, they realize they're not appropriate to leave yet, they want to stay. That's most of the people we have in that situation. So the exception is I'm out of here.
Okay, thank you. Dr. Schneider?
Hello, John Schneider. I'm a psychiatrist by training, board certified. Let me roll back a little bit further. Born and raised in Wisconsin, went to UWM, wanted to be a civil engineer, which may explain a lot of things. Dropped out of school and joined the Army. I was an anti-armor infantryman for about 8 years. I was involved in a serious motor vehicle accident, which I think is somewhat self-evident, and worked with the Special Forces Medic Course at Fort Sam Houston, where I got interested in medicine and got a medical discharge and went to medical school. It was a different millennia. So 25 years ago or more was when I went to medical school. I hated psychiatry. I was against psychiatry because of what it did to people and how it forced people to do things. I wanted to be an orthopedic surgeon and I didn't match, and I ended up becoming a psychiatrist through a series of events. And I love my job. This is a very complex, messy, hard thing. I'm a recovering alcoholic, so I have my own lived experience. I have a number of family members that I have lived experience with. Probably one of the most harrowing memories I have is sitting in the ER holding the cup of activated charcoal with soda for my loved one to drink, and they don't remember any of it because they were amnestic from the overdose they took. I have lived through having family members be voluntarily admitted and them refusing to sign a consent and not knowing what was going on until the day they got discharged. I've also lived through having my 90-year-old mom have an extended family member live with them and having to call the police and have the person basically sort of try to cajole them out of the basement, because when you call the police come and they do police stuff, right? So are they going to tear the house up, dragging the person out of the basement to get them detained because they don't want to come out? So I can come across as very rigid about the rules, but trust me, I understand and I've lived through some of this. The other side of this, though, is if we really believe in the autonomy of people and we really want people to be people, we have to give them the dignity of making mistakes. So that would be sort of my preface to the whole discussion. Now let me go into a couple of follow-up details. One, we have a specific mobile crisis team when people are on an emergency detention and they need medical clearance. We have 24 hours to get that statement of treatment director's supplement done. And because we don't know how long they're going to be at Frederick or St. Luke's or St. Mary's, we have a team that will go out and evaluate the person and do that statement treatment director's supplement while they're in a medical setting to make sure we can get to the point of hearing the case or not. There's some times where someone needs medical clearance, but they are willing to get care or they really don't need the emergency detention. I think that's the other cardinal point where people struggle in understanding is that there are lots of things that are patently unsafe. We can all look at them and go, boy, that's unsafe. The mere fact that something is unsafe does not mean, therefore, it meets the statutory threshold for dangerousness, which is what these two argue about all the time. And that's the challenge, is there are lots of things that are unsafe that just, they're not dangerous. Or they may be contextually dangerous. And this is where details and reports matter when family is talking to law enforcement. So if I'm wandering down a street, psychotic, without regard to my surroundings, but it's a back alley that there's no traffic on, okay. It's unsafe, it's probably not dangerous. If I walk onto 43 during rush hour, that's clearly dangerous, even if I show more regard and I'm trying to dodge between traffic. And that's where specific unsafe things and the amount of details and facts that are conveyed to the law enforcement officer so they can put it into the petition matters. Because it's the same issue when they get to MHAC. The doctor will look at it and they will read the blue form and they will talk to the person. And if those facts aren't on the blue form that they really understand, they're left reacting to what's on the piece of paper. Another high-level concept for folks to understand. Wisconsin is what's called a limited voluntary state. There are states that are truly voluntary states. So if you go to the hospital and you get admitted, and you go to a medical ward, whatever your problem is, right? That's a voluntary admission, which means you can get up and walk out at any point you want. There are states, psychiatric units are set up that way, where it's entirely voluntary. Wisconsin, as a limited voluntary state, requires 5110 is the voluntary admission of adults, and I think 5113 or 5114 is the voluntary admission of children and adolescents. Requires that you be informed in advance, which is why you have to sign in, of your right that you don't have a right to immediately leave. In Wisconsin, you have you have a right to request a discharge. The treatment team can hold you a business day. Okay? Keep in mind, a business day, Friday afternoon this week because of the holiday, actually means they can keep you till Tuesday. So they can hold you a business day to determine are they going to file that treatment director's affidavit or not, and hold you. Quite often, people who are a little skittish, when they read the admission criteria, when they read the admission petition, and they realize, oh my God, I just can't walk out, that makes them unwilling to sign in sometimes. It's a challenge, but it also protects people because once you sign in, it doesn't mean you just can't leave no matter how dangerous you think you are. Wisconsin has a unique balancing of rights and protections. And that's what really creates a lot of our challenges. Let me double check my notes to make sure I didn't miss any high level points I wanted to talk about. One call out for Milwaukee Police Department. There are lots of police departments in urban settings that will not voluntarily transport people to psychiatric facilities or medical facilities, and it's a wonderful thing that they will do it. Lots of other places, they just leave people where they are, and they don't even attempt to do anything at all. So I think that's one thing. Even though it doesn't necessarily go the way people want it every time, the mere fact that they're making an attempt, and we're using money to have law officers move someplace where they may get help, is a much better system than other places. So if a person gets committed, there is a specific procedure within the statute chapter called transfers and discharges. When the person is committed, they're committed to the care and custody of the county department. So the county department then gets to decide what happens. Clinicians decide the person is well enough to be out of the hospital. And the person leaves the hospital on what's called conditional release. There are a series of terms there. We have an internal process. There is a written policy on how to move people back to the hospital. There are two ways people can be returned to the hospital: for clinical grounds or for violations of conditions. If a person is going to be returned for violations of conditions, two things need to be true. One, there needs to be a factual witness who can testify to what the violation is. And two, there has to be a reason for the person to need to be in the hospital. If the hospital, if you have a technical violation, treatment isn't going to change it, they're not going to get hospitalized. The other way is clinical grounds. So if somebody is ill enough that they independently need to be in the hospital, their outpatient doctor just needs to write an adequate justification for admission, and the person can be moved back to the hospital. These are methods that they take a little bit. A treatment team can fill out the paperwork. it can take a day or two. It gets to us, we try to get them out. If they get in by 2 o'clock, we try to have them out the same day. They go to the civil process of the sheriff's department, and civil process comes to pick somebody up. It used to be very hard to predict, and it could take up to 2 weeks to get civil process out. Over the past 6 months, most of the returns I signed, person's usually picked up within 48 hours if they're able to be found. So the system is much more responsive than it used to be. If a person is on a settlement agreement, they can also be returned. Standards are essentially the same, but the county department doesn't have the authority. The court that made the settlement agreement, so we do all the paperwork, we forward it to court counsel, and they take it to the judge or the court commissioner and have it reviewed, and then they would issue the paperwork. So it can take a little bit longer if it's a settlement agreement, just for the logistics of getting it through all the places it needs to go. I think we have I know we have a BHS Legal Services at Milwaukee County WI.gov email address. People can email there, and we can get it internally to the right people. Commitment extensions, I think that's the other big area. The statute provides, well, let me step back for 1 minute. When I completed, I did residency when the Department of Psychiatry for the Medical College was at the complex. So all of my training was at the old complex. My first job was at the complex. I was an inpatient doctor. I was the inpatient medical director. I left. I went and I worked at Aurora as an inpatient doctor. I was when they started a unit for facility detained people, I was the medical director of that unit. And then I came back to this role almost 12 years ago now. So my whole career has been doing this. And the challenge is in moving people around, meeting time requirements, getting things done. Having paperwork filled out completely, correctly, accurately. Extending commitments. We have a staff whose assigned job it is to remind providers, send out a packet for them to evaluate the person. The providers fill out that petition, they forward it to court counsel. Court counsel reviews it for an initial review. All of those come back to me, and we have an internal work group, and I write a written opinion on basically a stress test. Does it meet all the legal requirements? All of the legal requirements for a commitment extension are the same as placing a detention. Namely, the person has to have a qualifying diagnosis, have to have behaved dangerously or be dangerous in the alternative evidentiary pathway, and be an appropriate subject for treatment. So I review the petition, I review the record, and I will make some assessment of, I think the person ought to be on a commitment, it ought to be continued, but the petition doesn't meet that. I'll send it back for follow-up information. And there have been some changes based in a number of Wisconsin Supreme Court findings in the past 5 years that have made it technically more challenging, that we have to be more fastidious and detail-oriented in what goes in those extension petitions. 20 years ago, it really was more of a, I don't want to call it a rubber stamp, but it was more of a pro forma, more of a expected. You had a reasonably written petition, it was extended. The thresholds are much higher to extend them in the last 5 years than they used to be. Anything I didn't cover, you think I should really?
No, I think that's great. A point that is often made we talk about. So I used to be a CSB caseworker, community support program worker. I see some colleagues out there who are in that space. So CSPs probably serve 90% of the people that we have under commitment. So I think we have 17 teams today. We have a county operated team. We have a bunch of partner agencies. If you're a caseworker and you have a client who's on a commitment and a family member comes to you and says, well, they missed their meds last week, I need you to detain them. It puts you in a pretty tough position because missing, it's not probation. It's not like a probation where a probation agent can bring you in on a sanction. We're talking about mental health treatment in an inpatient setting. So you have to need that. And so it's not just reporting a violation. And I think there was a time when you could just say, well, they missed their meds a couple of times, we're going to bring them back in. And it's been a very long time since that's been the case. But I do think there's this challenge if you're the provider, because if your client with whom you're trying to establish this treatment relationship, many of the most challenging cases, and the cases that really cause a lot of challenges, are people have zero insight into their illness. It's a really unpronounceable word, anosognosia, I believe is the way to say it. It basically means you have no insight that you're sick at all. And in fact, many people kind of blame the system for their challenges. They say, well, you're all crazy, I'm fine, right? If you're a caseworker who's trying to build rapport on someone who might be critically housed, they may have all kinds of other challenges and entanglements, and the first meaningful thing you do for them is call the county and have them re-detained, you kind of blow that relationship forever. So you might, as a family member, you might sense that the caseworker is reluctant to take that role because it's a total contradiction, and really what the best outcomes are in voluntary cases where people have some insight and they establish rapport with somebody. It doesn't always have to be a doctor, it doesn't always have to be a caseworker, but having someone in your life that you can kind of process this stuff with is really important. We have many folks that only person in their life is that caseworker. And that worker might change a couple of times in their lifespan. There might be some turnover, and it might be a relatively new person. And so that sometimes creates a challenge in that they don't want to be that person. They will if they believe that person is dangerous. But really they need that evidence, they need that actual support. Because those are the cases that Katie and Al will fight over, and eventually it's going to get thrown out. And that person's going to get discharged. Nothing has been gained except you've lost the rapport with that customer, and it might never be returned. Because some folks really, I still have people who are mad at me about commitments that were initiated in the 90s. I still bump into people from time to time who bring up the fact that Michael Lappin put me in the hospital. And so there is something that we try to maintain, we try to move forward with our folks. I think we'd all agree that voluntary treatment is best. Something like 90% of the folks we work with probably are either voluntary or quickly sort of gain some insight and move forward. It's really a smaller number of folks who have that insight issue or for whatever reason reject treatment, and that really are the ones that we are challenged to manage that line of voluntary versus involuntary. So for the whole panel, unless there's
I was just going to, I'm working on a research study and have been doing some background work. And these are fascinating numbers for people to wrap your minds around. If you look at the general population, the rate of civil commitment across the whole population is about 0.2%. That's not a whole lot of people. When we look at a population with severe and persistent mental illness, it's about 6%. That's across all United States. So every standard of dangerousness in all settings, it comes out to about 6%. That's not a whole lot of people that have to be treated voluntarily. Arguably, there are challenges with people having choice and autonomy, but back to the dignity of human beings, we have to give people the capacity to make mistakes.
Thanks for that. Sort of for the whole panel, sort of as we sort of wrap up here and get to some questions, how have things changed over time? So I started my career here as a caseworker in like 1997-ish. Lauren worked at PCS as an RN at one time. Dr. Owen had done some time working at PCS. Our legal folks have shared their experience. Dr. Schneider's had a couple of different standing. What has changed over time? What are the really significant things that have changed from your perspectives? And just, it would be helpful, I think, for the group to recognize that this has been a moving target for a very long time. So whoever wants to jump in.
So if we look at schizophrenia as a prototypic illness and severe persistent mental illness, the largest deficit of schizophrenia is lost life productivity. What we find is drop-in centers. What we find is good, affordable housing. What we find are those larger community things, not treatment, not services. Those are things that there were more of that have dwindled over time. And that impacts what everybody else does.
Yeah.
Well, I've been doing this since '93. We now have a reception hospital where it should be, and not out in Wauwatosa, which is
And you're
much
talking about MPAC
Right.
across the parking lot.
which is much better for the community. We moved away from institutional care, where we had units. Hilltop had A through F, G, of people just living there in perpetuity. Lots of locked inpatient units at BHD, and we've moved away from that. And lo and behold, it hasn't been any kind of a catastrophe. Everything seems to be working just fine, and instead of people being warehoused, they're in the community getting care. So I think we're in a better place where I stand now than where I was doing this as a defense attorney in 1993, 1994. Top that, Katie.
They're not competitive at all.
When I was in high school in 1993. So I've been a public defender since 2010, and I've been doing the mental health stuff since 2015, 2016. And so my memory is not as long as others, but I think something that's really, like, our job is harder because we're physically going all over the county to see people, right? Like, we used to be able to just grab the paperwork, walk upstairs to BHD, go to the different units and knock out 30 client visits in a very short amount of time. So, but it's better, I think, too, a lot better. I think we, as a community, there used to be on a typical Wednesday when you're seeing everybody that came into the hospital over the weekend, there could easily be 30, 40 people on a list that were at one point emergently detained, many of whom are quickly getting discharged. But they're building up this track record of mistrust, just like Mike was talking about. And I think we as a community and the legislature, I don't compliment them often, but one thing that they've done is really pushed, recognizing the science behind it too. We've really pushed to say, if people are willing to do stuff voluntarily, that's where you're going to see the best results. Anybody telling you, anybody who's tried to have a strict diet of what they eat, right? Like, somebody telling me I can only eat X, Y, and Z is going to make me not want to do it. And mental health treatment isn't different. And so I think as a community, we've moved away from sort of using our system as the backstop to everything, but still recognizing that people can come in and get services and treatment and stuff like that, and do rely on the government to help with those things. And that's, in my opinion, how it should be, but not involuntarily, instead focusing on the voluntary nature of things. And I think I would happily be put out of a job and not have to do this type of I love it, right? But I would happily not have to do this type of representation because an adversarial system is great for lots of things, but the human element isn't as embedded in it as it should be. And so I think that's something that's changed for the better. Budget crises and all those things are things that have changed for the worse. But I do think that sort of, as Dr. Schneider said, putting the humanity back in how we do representation of people is something that's wonderful, and it should be expanded because people should have a choice in doing stuff, and you shouldn't be, I think also recognizing mental illness not as sort of having a criminal hook or things like that, but recognizing it as a health crisis is something that has been tremendously helpful, looking at it as a public health space as opposed to looking at it as, I don't know what it was before, I think is a really helpful, positive thing too.
Thank you. Lauren?
I should have went first.
I didn't warm them up with this. They don't know this is coming. So.
As Mike said, I've been with DHS for all 12 years of my career. I started in PCS as a brand new nurse. And for my experience, I'm not law enforcement, but my experience over the years are our partners in this system that are not at the table. They know they're not the experts in this work. They have been more amenable to working with us, learning from us. Aside from the City of Milwaukee's Police Department, other agencies are working to ensure their officers are crisis intervention trained. They continue to reach out to us more and more to expand our CART teams. The Wauwatosa team just started earlier this year. And so I think in that, not only do they know that they're not the experts in these situations, they would prefer to have support from others of us in this system, but they're also less likely to detain in situations than when I first started working in this field. People were brought out to the county's hospital for every little bitty thing, and it was like, oh my, seriously? You detained somebody for this? And I see that less often than I did in the beginning of my career. And then with that as well, just intentional efforts by Milwaukee County, by our system partners to expand our community-based services, try to catch people earlier in a crisis, before a crisis happens, work more towards preventative measures to help avoid those health crises when possible and help to ensure safety when we can't avoid them.
Thank you. Dr. Owen, you've seen both versions, so what do you think?
So I worked as a staff psychiatrist in PCS for 7 years, which included some crossover with my residency training. And I'll say that complex MBHS did do great work. It's very missed. The volume of subject matter expertise that was housed in that facility and centralized there was a really great training environment. I think that's a big miss for people now who are coming up and training to be psychiatrists. And I think the growing pains in transitioning over from county as a centralized complex to the different services, and me specifically with the Mental Health Emergency Center, they were interesting to go through. I will say now, the fact that MHEC is set up as this very unique joint venture where there is, 50% county investment, but then the other 50% is all of the other major health systems. It's Ascension, Wisconsin, it's Aurora, it's Freighter, it's Children's. There's a level of, almost compulsory engagement now that was not there before. I think it used to be much easier to say, I work in the Freighter emergency department. This is a patient that should go to PCS. This is a county patient. You still hear remnants of that, but I mean, it's now, you have a system director on our board that listens to and is engaged with the work. And I think now there's a bit more ownership in the community that these are all of our patients and that we all work to take care of these patients. So I think that's been a big plus. EHS continues to do great work. The fact that they're now across the street instead of right upstairs is different, but it also compels a little bit more intentional connection as well. So I think all of those things have been evolving factors, mostly positive.
Well, thanks for that. And I'll just say, so I've been here 9 years last week on the 16th. So it's been 9 years. In that time, we closed the hospital, we've had a pandemic, we built the great new building. There's been a lot of challenges. My sense from a historical perspective, having been a CSP person way back in the 90s, is somewhere around 2010, we started moving forward with things like CART and crisis mobile expansion and community support programs and expanding. And at that time, I think there were 17,000 emergency detentions at PCS in 2010-ish, something like that, 16,700 or whatever. And for the last 4 or 5 years, we've been right around 8,000-ish. And we always believed that there was a certain number that was appropriate, that there was just going to be a certain number of folks that needed that level of care, but we never really knew what it was. And I think the successes of Lauren's team in getting out earlier, the expansion of access into the clinic, the improvement in medications. When I first started my career, most people were on medications that made them feel terrible. Frankly, they feel terrible. And so in 25 years, we've seen some improvements there. We've seen an improvement in community-based care. We've seen a lot of better outcomes, but there's still gaps. And I just want to be honest, it is not a perfect system. People fall through the cracks. Some of our customers are extremely savvy, and they know the system inside and out, and they know exactly what to say. And it's exasperating for family members when they say, well, why are you listening to my daughter or my son, not listening to me? And it's like, I am listening to you, but I have to listen to the whole situation, and really that customer is the one whose rights are about to be suspended, essentially. So we don't take this lightly. I know I've had lots of really complicated conversations with a lot of folks. Some of them are probably in the room, but we're always here. We always will listen to these cases. We're certainly not going to dissect a case in this venue, but I am open to, and I'm also open to making connections with the panel. If someone wants to talk through a case or get some advice or sort of come to understand within the realm of what I can disclose and what I can share, I'm happy to do that. My contact information will be part of this. Also, we have some questions that were submitted. I think we got to some of them here. I was trying to work it in. But we will publish, and we'll send all of you copies of our answers in detail. We'll spend a lot of time on it. We'll make sure it's great. What we find is as we build knowledge, people are more comfortable with the system and more effective in getting their loved ones care. And then, any time there's a concern that comes up about a case, I am happy to come out and talk to you. I'm happy to address it or make a connection with someone in our system who might be best for that. We have some very passionate folks that come out to our meetings, and I've spoken to a lot of them, and personally, I try to reach out and have that personal contact with families to learn more about our system as we try to make it better. I'm never going to say everything's perfect. There are pros and cons to what we've done, but for the most part, the average person that we serve who has a serious mental illness has a better quality of life today than they used to, and that's in the face of the challenges with housing and income and all of the societal challenges around mental health. We're a work in progress. The Mental Health Board has a charter that they follow, essentially, that basically says our services should be upstream, preventative, least restrictive, client-focused, client-centered, and that's really how we move forward. Every decision we make is based on, are we following that charter that's in 5141? The Mental Health Board, who are chairwoman, Mary Laura is here presently, we're trying to make those decisions. You're all of our customers, but we have to focus sometimes on that patient who's the person that's really in our focus, because that's our role as a county department and as a system. So we have just a couple of minutes. If there's a question or a clarification that someone wants to ask in the moment, again, I don't know if we can answer every question, but I'd be happy to try to answer it or have the panel. If not, we'll get to them after the fact.
You brought up police a lot during this, and Wisconsin's one of two that police cannot do the 51. Was any police department invited to this panel? I would love to hear from their perspective what these chapter ones look like.
No, that's a fair question. We didn't invite law enforcement. I guess that was maybe an oversight. But I know we work with our Community Justice Council very closely, and we actually had a meeting about 3 weeks ago where we invited a number of law enforcement agencies in, because it was consistently being discussed that the petitions were not passing muster. And sort of after the fact, we were learning about stuff we wished had been included in the petitions. And so there is an effort underway with CJC and with some of our judges to provide better education for law enforcement officers. I think what it comes down to is MPD and maybe the larger municipalities, and I'm going on a limb here, so lawyers can check me if I'm wrong, but like the bigger municipalities do this all the time. They're better at it and they get better training. Sometimes, though, a newer officer, more one of the suburbs, they don't do as well, and those petitions are often more likely to fail. Dr. Schneider, you want to?
There's 21, I believe, jurisdictions within Milwaukee County that are able to write emergency detentions, plus minus margin. I might not be counting Marquette Police or something like that, but it's about that number. Some of them are very low volume. Even if you train them because they're low volume, they don't necessarily, because they don't have the experience, do as great a job. The clarification I really wanted to make is every state has law enforcement as a civil detention actioner for commitments. The thing about the only two is that they don't have, Wisconsin doesn't have other people in addition. So if you go to another state and you're in the community and you need to be detained, it would be law enforcement that would be detaining you. So if you are in the bus stop in East St. Louis, right, it's going to be law enforcement. If you're in the hospital already in the emergency department, it may be that a physician or a social worker can file a detention to hold you once you're already in a facility. There are very few jurisdictions that use non-law enforcement to have police power to turn people off the street, just to clarify that.
And I'll make a point. So Jefferson County for like 35 years has had essentially what is an alternate pathway because they use their juvenile probation agents under Chapter 51 can be trained to detain youth. My sense is that might not pass legal muster since those officers don't have jurisdiction over adults, but they've never been questioned. But the truth is, in Jefferson County, those staff essentially coach law enforcement how to write the emergency detention, and then law enforcement provides the transportation. So there's a belief that Jefferson does something that we all should do and it would be all different. But in reality, the only difference is the county coaches them on every detention and summons law enforcement to the scene to transport.
I was here when we had the treatment director pilot also, and the biggest challenge was that team would get called out and law enforcement had already made a decision they didn't need them. And even though we could do it, it wasn't utilized. The secondary problem was if a person really was acutely dangerous and assaultive, they weren't able to contain the person. They had to call law enforcement anyways. So CART is probably the best, most evidence-based model where you have law enforcement with a clinician. I think we're also starting to do some crisis with EMS response.
Yeah. We're in early conversations with the City of Milwaukee's Unified Dispatch Center to work with them on expanding alternative response to mental health calls. So right now, a partnership with Assistant Chief Parrish with MFD and Director Bueno, I believe is his name. We're early conversations to explore what that looks like. And I think a part of the challenge for us is representing all of Milwaukee County. If there are 21 caregivers, so independent law enforcement agencies, probably half that about dispatch centers and how those pathways work, is us picking a partner kind of to start with, pilot some stuff and grow from there about what that looks like, because these situations may play out differently in each jurisdiction.
Thanks for that. I think we have time for one more. So one more question?
Can I just add one thing really quickly? Because my colleagues in the criminal part of our agency would be remiss if I left this on the table. But I think there's a lot of information that's, some of it's dated, some of it's current, that too often, and I think everybody would agree that too often we're using our jail as a mental health facility as opposed to using the mental health services that are available in the community. And we're having really good discussions to try to, it's been called bridging the gap, but we're really trying to do internally, to the extent that we can, doing case studies and really looking at decision points, right? Because a police officer is the one making the decision to turn and go to MHEC or turn and go to the jail. And we want, certainly I want, and my colleagues want on behalf of our clients, to make sure that decision is the right decision. And so we're really trying to do education amongst the law enforcement and amongst our system partners to really say, making the right decisions, because our jail shouldn't be the largest mental health facility in the state, right, or in the county. And so I think we're looking, and I'm talking with my colleagues all the time who are representing folks in the criminal system, how can we do this better, and how can we make sure that people are coming in the right door? Because the challenge of the 24 hours thing that we've heard ad nauseum about, right? What happens is if the police officers pick the wrong door, they can't then backtrack and take them to see Dr. Owen. And so I think collaboratively we're really trying, it's not that many people. It's not as many people as folks think. But we're really making sure that of the folks that are, taken into police custody, that the officers on the street are educated, not the CART team, because they're very educated, but the everyday officer on the street is making the right decision too. So we don't have people that are suffering or going through horrific things within their own mind when they're at the jail and not getting all the services that they should. So that's something we've really been trying to focus on, because that's I think something everybody agrees we could do better. And so when we talk about law enforcement and really trying to make sure that not only the brass that's, making the big decisions, but the officer on the street is really making the right decision and getting the person to the right place, because we don't want our criminal system to be used in lieu of an involuntary mental health system or a voluntary mental health system, which everybody agrees would be better.
Thanks, sir. Okay, we have two hands up. We'll make work. Sandy?
Yeah, I guess I have to take issue with, someone said we presume competence, and I don't believe someone who is in severe psychosis is competent to make their own decisions. I believe psychosis is a medical emergency, and it's kind of similar to Alzheimer's. We wouldn't let people with Alzheimer's who don't have awareness, on the street. We wouldn't have them in our jails. But this is happening to our loved ones, and I hear it all the time. They're in jail. We don't know where they are. And also another question is, when they leave AMA against medical advice, do they just walk out the door? Is there someone there to help them? Is there a family member called? What if they don't want to call a family member? Do they just walk out in the street? Because I don't believe that someone in severe psychosis is competent. They often do not understand that they're sick.
So it was me that said that, and that's because that's what the ethics of my practice and the law in Wisconsin says that we have to do. So it's not my role as somebody's adversary counsel or advocacy counsel or express wish counsel to challenge delusions and things like that. And quite frankly, I represent a lot of people with Alzheimer's who I also in my role presume competence and presume, because that's what the law mandates that we do. It's not I'm not a medical doctor. I wouldn't make it through medical school probably, but it's not my job to sort of determine what's motivating somebody's decision making. In my role as their express wish advocate, that's why there's other system players that are sort of the ones that have to present the evidence. So it's a hard thing. When I first started my career, it's a hard thing to sort of accept, right? That I'm having somebody talking to me about things that are not my reality based, and they're in or I represent kids a lot, right? So I'm talking to a 10-year-old and I'm taking my direction from them. In any situation, it's what my ethical role is, as outlined in the statutes and outlined in Wisconsin laws. And so I'm the only person, right, that's assuming that and that's fulfilling that role. And that's why the due process of the system are the ones that have to, essentially push. I was talking about me pushing back on other people, but they have to push back on me if that's not the right thing and that's not the reality that everyone else is in, what my client's in. But my role as advocacy counsel is directed by ethics and the statutes, and that's what they say I have to do. So it is not my job to question somebody else's reality, and so I, as a human, I completely understand what you're saying, but my role in this particular situation and in this system is to presume competence, because that's what I have to do. Now, I'll tell you, sometimes it's very difficult to have conversations with people, and but that is my role in all of this, and that is how I ensure that people are getting the process that they're due. And it's Al's job, and it's Dr. Schneider's job, and it's the police's job to look at those other aspects. So I'm just one person sitting in a courtroom working on things, but there are other people whose job it is to check that and to push against that. And that's exactly where sort of the term due process comes from, right? That it's my job is to make sure people are getting the process that they're due, and I have to empower them to make their own decisions. And that's why sometimes we call ourselves civil rights lawyers, right? Because that's what we're pushing. We're protecting that liberty. And it's up to other people to take on their roles and push against that. So I have to have that role because I'm not their guardian ad litem and I'm not a best interest attorney. So that's absolutely why that's why I have a very unique role in the whole system, and my staff does as well, because we're taking a very different perspective of things that most people in their everyday. I had to train myself to get into that position, and I and that's why I'm so passionate about where I come from, because I am that person. I'm the only. There's lots of people that advocate in other wonderful ways, but I'm that person in the courtroom for my clients that are speaking to that empowerment, even if it's not based in my reality, it's based in their reality, which might be something that we don't all agree on, right? So.
Thanks for that. Okay, final question.
Yes, sir, thank you. We work with the wonderful Dr. Owen at MHEC. As she stated, we see most of our clients on an involuntary basis brought by the police and or voluntary at their request. Most people that come in there on a voluntary basis are brought in by the police. Almost all of them discharge and say, oh, I feel better, I just want somebody to talk to. So my question is, in lieu of utilizing our resources properly and doing what's best for the patient in that moment, how are the police interacting with CART? Because I feel that CART could be, sent out there, crisis could be sent out there instead of that dispatched police officer who's then just bringing us who gets discharged after talking for 10 minutes.
Sure, I will have the panel address it, but I think one sort of part of the answer is just in the data. So 16,000 people came to PCS 20 years ago, and only 8,000 come to MHEC, but we serve all those people still. Many of them are served by Crisis Mobile, by community-based services, by walk-in services, by peers, and so I think what you're seeing is sort of that additional population just hasn't quite got connected to those services. Would you agree, Lauren?
Yep, I think that's 100% fair to say. In full transparency, a large part of my job is marketing and advertising to make sure that the turnover that happens, all across our system, that people are aware that hopefully before you ever have to call the police, you could call the crisis line. We can come out and you can come and talk to us. Or maybe CART has come out and spoken with them, chosen not to detain, chosen to make the decision with that person to leave them in the community. Regularly, then someone else calls the police again, and that opportunity may have been missed. But personally, I think that is the option that is available and could be utilized more often, whether it be from the initial call coming into law enforcement from dispatch, whether it be from those patrol officers on scene, or community members calling in and making the requests, like, can you please send CART if they're in service? The other thing in full transparency is CART isn't always in service. So we partner with our law enforcement officers to operate CART, but with only an officer and not a clinician, it isn't a CART team. And sometimes there are officers that are a member of CART that may have to come out if we don't have a clinician available for them that day, or we have a clinician available and the law enforcement officers on vacation because they have a hard job. So I think that's a part of it too as we work to expand CART is availability of it and then knowledge of all of our crisis services that won't always mitigate a person from going to a higher level of care, but it is an option that is available. And please help spread the word.
I think I'd frame that whole situation a little bit differently. Director LeGrand has wisely and with vision led us to really embrace no wrongdoing. The other big principle is any crisis system is based upon the person self-defining what a crisis is. All of us within the system need to be able to take people walking in the front door and assessing and getting them rapidly in a resource-sensitive way to what the right thing is. But we should not try to prioritize or deprioritize access points. I think expecting cops to go, somebody has a problem, I'm going to take them somewhere, whether they call crisis would be great, but I think having them seen is more important than having them seen by crisis or CART or somebody else. So there's going to be a percentage, we should expect it, we should know how to deal with it.
I appreciate that. I also appreciate all your help. Thank you to our esteemed panel. Thank you all for coming.